Next case is Parker versus Parker.
Good morning.
Hi. See you both. Okay, Ms. Powell, you're up.
Good morning. Thank you, Your Honors. My name is Megan Powell. I'm here on behalf of the appellant, Stacey Parker. I'd like to reserve 5 minutes for rebuttal, and may it please the court. So I just want to start by noting that with each of the issues raised on appeal in this case, there's one consistent underlying issue, and that's that the trial court did not provide sufficient factual findings in the amended final judgment, which is required by the statute 61.08. It kind of makes this an interesting appeal because there's a lot of guessing going on, but if you'll bear with me on that. The first major point that was raised in the brief is that the amended final judgment specifically states that it utilized the party's gross income in the alimony determination. Now, what I'll tell the court is, based on the record, I think that the numbers labeled as gross in the amended final judgment were really the numbers that would constitute the net income for the former wife, but the gross income for the former husband. I base this off of the transcripts from the final hearing. Those were included in the supplemental record. The former husband's chart from the final judgment, as well as my calculations. I'm by no means a mathematician, but my calculations of what the gross wage would be and the net wage would be at minimum wage, which is what former wife's wage was imputed to.
This is what's interesting, Ms. Powell, because you're right that the judgment itself mentions gross. And if you look at the transcript, the judge tried to say, no, I'm using net. I backed out the amount. Here's what's amount. And then it was follow-up questioning about what was the number and trying to articulate that it was a net number that the judge used. So was it a net number? Was it misstated as a gross number? And what is it in this case?
So I think that's the point I was trying to make about there being some guesswork in this. As I said, I think that the 1,500 or so figure of the former wife's income used in the amended final judgment is the net of minimum wage. I think the 6249 plus 2,500 number for the former husband that was utilized was that gross figure that the court was talking about. No, I backed it out. It's kind of confusing from the transcript. I got that gross figure from if you look at the child support guidelines, child support guidelines actually utilize the gross income number. And so that gross income number is equal to the 6249 number plus the 2,500 number. So that's why I think that was utilized in the amended final judgment. I'll be honest with you, I'm not very good at math. This was one of those cases where I was very confused by what is it, the gross or the net? But that's the best I could come up with, for Your Honor, on whether that was used. The real issue is, no matter how I did the calculation, so I took about a half a day and did, by taking both nets, both grosses, and net and gross based on what the final judgment says, and did the math based on the expense charts that the court said that it relied on in the amended final judgment to come to that need and ability determination. And I couldn't get the math to work out either way. So no matter what the court used, that number for the expenses has changed. And I'll get into that in a little bit. As I said, I think the reason for this is there's a lack of clarity as to what that net number should have been for the former husband's income. And because of the parties' competing charts. But the bottom line here is that if a trial court uses gross income, or if the final judgment states it uses gross income, it's reversible error because they're required to use net. And in this case, I don't think it's clear which one was used. So at the very least, I think the court needs to go back and clarify what was the gross versus net number, what was used, how these numbers came up. But that actually leads me to the next point, which is that there are not sufficient findings to determine whether the amount of alimony was correct based on the net income. So even let's just assume that the amended final judgment uses the correct net income number. The problem we have is that, and again, this is just based off of my review on the record because the amended final judgment doesn't really clarify, but it appears that my colleague here, Ms. Hooglander, who was trial counsel, and I apologize, Ms. Hooglander, if I pronounced it incorrectly. I believe she sent in, as well as Mr. Hurwitz, competing letters talking about what their arguments were as to the need and ability of the parties. Based on the language of the final judgment, or the amended final judgment, it looks to me like the court largely adopted the amounts that were submitted by Ms. Hooglander. And he said that he based this off of the charts that were provided, as well as the testimony at the final hearing. Now, the reason we know he didn't just adopt those numbers is because the ability number for the former husband wasn't just adopted from that letter. If I'm not mistaken, the letter was something in the region of 1,500 for the husband's ability, and the court made it 1,690 something. So there's an expense there from the husband's chart that the court disregarded or rejected. The problem is, we don't know what that expense is. The court didn't say why it gave the ability number that it gave. And the reason that's important is because the expense charts include items that are not necessarily appropriate to have in an expense for an alimony consideration. So we had items that were childcare expenses that were only relevant for child support. We have items that the parties agreed to share on a pro rata basis in the MSA. We have items that the former husband testified were not his own expenses, one of which was $200 a month in boat gas for a boat that he doesn't own. So it's one of those situations where, unless the court gives findings in the amended judgment, we can't look at these expenses and say, are these appropriately calculated? Is the alimony—
Let me see if I can understand the nut of your argument, because I share your frustration with trying to piece together the various snippets of the record and how they tie to this final judgment. If boiled down to its simplest terms, I think that your argument is either the trial judge used gross income incorrectly to determine alimony, or if there's some way to figure out that he did use it correctly, it isn't in the judgment. So in other words, the judgment contains insufficient findings to allow us to determine whether he used gross income or net income, or what he actually did do to compute the alimony figure. Is that maybe overly simplistic, but is that essentially where you want us to go with this?
And it's pretty close, but there's just one thing that I think needs to be added to that, which is that even if the court used the net figure, which if he did, that's great, but it doesn't say it, I still don't know what those expenses are. So whether he used gross or net, it doesn't really change that the expenses—
There's still a problem with the expenses.
Yeah. But otherwise, the court summed it up pretty accurately. And really, the problem with this is just that we can't go back and say whether this is correct. We can't go back and say whether the former husband's ability was under or overstated. And so I think that if anything, this would have to be reversed so that the trial court could go back and look at whether it was net or gross, if it was net or gross, which expenses it included or did not include. And I do think that there are some expenses that it seems were included based on the numbers, just because there's only a $160, $90 difference between what was the former husband's proposed ability and the court's ordered ability, that those expenses should have been included.
Wait, so if I may, Ms. Powell, so
Certainly.
How do you reconcile that with the fact that your opponent says you failed to provide complete transcripts of everything? That
Yes, Your
if you
Honor.
had a transcript, that would just maybe perhaps it would eliminate what expenses was used. It would eliminate the amount that was mentioned. We have snippets as to what the court appears to have done in terms of the net. How do you reconcile with the fact that because there's a lack of transcript for us to have a full review to warrant a reversal in this case?
Yes, Your Honor. So number one, I would state that under section 61.08 Florida statute, it says the court shall make written findings, and it's a non-discretionary rule. I think the reason for this is to avoid situations like this. I agree with the court and with my colleague that, at least to the extent that if the final judgment contained adequate findings to give the reasoning for and the decision and listed the expenses that it's supposed to list, it would be very hard for me to sit here and say, we preserve the issues for appeal because there are incomplete transcripts from below. What I will tell the court is I think I wasn't trial counsel on this case, but it looks to me like there was not transcripts for all of the segments of the final hearing because it was in like 3 segments. So there's a transcript missing is my memory of it. But this court and other Florida courts have held that when an issue is apparent on the face of the record or on the face of the order that's being appealed, the lack of transcript doesn't preclude review. And I think if anything, the lack of findings precludes the meaningful review in this case and not the lack of transcripts, because the findings is really what's the most important here and the part of the statute that's non-discretionary. The case law is pretty clear that not having sufficient findings is reversible error on its own because it's on the face of the order. And I would point the court to the Horowitz case, which I talked about in the brief a little bit. And that one was one where the court even included some findings and included the statutory language with respect to those findings, but it wasn't sufficient to know why the trial court decided what it did, and the findings were not enough. And what they said was there is some indication that the court accepted some expenses over others, but then it didn't clarify which ones those were. Again, to answer a little bit closer the court's question, I do think if the court had provided the sufficient findings, there would be no error on the face of the record and the lack of transcripts would be a problem. But I think in this case, because that amended final judgment doesn't have those findings, it's apparent on the face of the amended judgment and therefore it's preserved for the appeal. I want to also move on to the argument about the durational alimony. So one of the things that we talked about was that the former wife asked for durational alimony for the length of the marriage, among other things. This was a moderate term marriage. The parties were married for 12 years. So durational alimony is pretty common in those marriages or divorces. Now, the statute states that durational alimony may be awarded when permanent periodic alimony is inappropriate. Durational alimony is usually appropriate when the marriage is of a moderate term or a short term of longer than 3 years. And the reason
Did she, and Ms. Powell, did she, I'm looking at her petition, didn't the former, didn't she also, her petition requested other types of alimony?
Yes, Your Honor.
All right, just want to clarify that. Okay.
No, understood. I believe she asked for durational, bridge the gap, transitional, and then she asked for it on a permanent and temporary basis. So under Florida's pleading standard, I think that would be sufficient for asking for permanent alimony. But by the end, at the final judgment, she stated a preference for durational alimony for the length of the marriage, which would have been for 12 years. So in terms of why I think the statute says that durational alimony may be awarded when permanent periodic alimony is inappropriate is because this does come in a case where the case law says that moderate term marriages are a gray area in the law. There's no presumption for or against permanent alimony because they're close to the cutoff for a long-term marriage on occasion. I candidly haven't found any case law on this point. I looked, but just based on the plain language of the statute and the case law I've cited in the briefs, it at least seems based on the statute that the trial court should include why permanent periodic alimony is inappropriate if it's going to award durational alimony instead, just because it says may be awarded when permanent periodic alimony is inappropriate.
But if a party says, I pleaded for all of the different kinds, including permanent, but I should get durational, doesn't that presume that the permanent alimony is not appropriate?
Not necessarily.
Hasn't the party said, well, permanent alimony isn't appropriate here, Judge, we should get durational? Isn't that enough?
So I think what the court is asking me about is a waiver of the other portions of the requested alimony. I do recall that issue being briefed in
or invited.
So I would just point the court to the Rivers versus Rivers case, which is a first DCA case where a similar situation happened where the former wife asked for numerous types of alimony. And then at the final hearing, she actually testified that she didn't want alimony at all. She didn't even just say, I want one over the other. She said, I want my kids. I don't want money. I want no alimony. And the trial court said, taken in isolation, that statement might have seemed like a waiver and that she was only asking for custody and not alimony. But then the court said, really, this was just her expressing a preference for a specific type of award. I still think that in the case of the statute saying that durational is appropriate when permanent is inappropriate, it requires the court to at least state why permanent wouldn't be appropriate. In this case, I think it would have been as simple as it's a moderate term marriage. Permanent alimony is more appropriate in a long-term marriage or some other type of finding, but we don't have that in this case.
Well, yeah, well, go ahead. I'm sorry.
Oh, sorry, Your Honor. The biggest issue, though, with the durational alimony is just that the court only awarded it for 5 years. The parties were married for 12 years, so this is for less than half the length of the marriage. I have looked through the record. There are no findings as to why it was 5 years. The letter from former husband's counsel stated he had the ability to pay the $1,500 for 5 years, but otherwise there's no indication in the record as to why 5 years was the number. I can guess. I think the minor child was 13 and at the time of the final judgment, and maybe the court thought in 5 years' time she's not going to need as much money. But again, that's me speculating. And I think that that's the whole problem with what's happened in this case, which is that the amended final judgment, we're not supposed to have to guess what's in it. We're supposed to be able to read it and understand why the ruling is the way that it is and what the alimony number is. So,
Ms. Powell, you are into your rebuttal time.
thank you, Your Honor. I'll conclude and leave the rest for rebuttal, but I would just state that we're going to be asking the court to reverse, to allow the court to revisit its rulings on alimony. And if it has findings to include them. If it doesn't, to hold a new hearing so that it can make the required findings under the statute. Thank you.
Thank you. Ms. Hooglander?
Good morning, Your Honors. Ingrid Hooglander. I have the privilege of representing the appellee former husband. And as my friend on the other side mentioned, I was also trial court. I have to say this is the first time I'm making an oral argument since law school 25 years ago in moot court. Actually, probably 28 going back to the first year. So just be kind.
Like riding a bicycle, Ms. Hooglander.
Okay. But if it pleases the court, I'm going to briefly summarize my allegations and then respond directly to some of the points that my friend from the other side made. I would argue that the court did utilize the net income for both of the parties. And I understand that the final judgment in this case, as I think you said in one of the prior arguments, it's not the cleanest and prettiest, but the judge did get the job done. And I should also mention that this was Judge Moody's first final judgment in family law when this was drafted. So bless his heart on that one. But towards this, if you look at page.
Didn't he say, Ms. Hula, that he's been on the family law division for 4 months? That was my recollection that he said.
Oh, yes. Yes. We were both of his first 2 trials was I had both of his first 2 on a separate case and on this case. So we learned very quickly how to assist the judge as it related to getting up to speed, but he was absolutely amazing and picked it up phenomenally. But towards that end, if you refer to page 210 of the record, the court references the order as it relates to alimony, and the court specifically says they found the base wage, imputed the former husband at $2,500, found that the wife's gross monthly income was imputed at the $1,535.41. I agree with what Ms. Powell said. The court had previously imputed in the transcript, and that would be from pages 217 to 225, the former wife at minimum wage. And this is the hard part of being trial counsel, and this is the hard part of knowing what happened at the full hearing, as the court, have only been provided with the excerpt of the husband's cross-examination, not the direct, not the redirect, and none of the testimony as it relates to the former wife. So working off the record, the writing of this brief was extraordinarily painful because you couldn't insert anything that wasn't in the record. But towards that end, the court should have indicated that it was $17.33 which was minimum wage at the time, $10 an hour, 40 hours a week, 52 weeks out of the year. And the court here put in the $1,535.41, which I would argue is harmless error because it actually imputed less money to the wife, which actually inured to her benefit as it relates to this. The court then states in the next section that it finds, based upon the testimony received and the evidence presented, please look at my exhibits, chart B and C. And I believe that Judge Moody found it easier to point the court or to point the readers of this to those documents in order for everybody to understand what the judge did. When you get to those documents, and I would refer to, I'm trying to make sure I have the record, I know you have before you, but the letter starts on page 1240 of the letter starts on page 1240 of the record, but it specifically references the finding that Judge Moody made on May 23rd, which was before the May 26th status hearing. And it specifically indicates that the judge had awarded $1,500 in durational alimony for a period of 5 years. You then turn to the numbers that we were requested by Judge Moody to provide in order to allow the court to address, because the judge did not have the transcripts, he just had his notes. And so the court had asked if we would do the comparisons. If you review both comparisons that we did, page 1242 and page 1243 of the record, you will note, and then I hate to say flip back to where the finding is, the court here said that the husband should pay $1,696.21 a month for a period of 5 years. The judge didn't need to include the letter as part of the exhibit. He could have just included the comparison, which is what he referred to. The letter specifically addresses his prior finding of the $1,500, and I'll wrap this up in a nice little bow in just a moment. You do see on there, and in the finding that the court makes in the final judgment, that the wife's need for alimony is $3,158.59. If you look at page number 1243 of the record, at the bottom, the last number is exactly the number that is the comparison of the wife's financial affidavit with her testimony that was provided, that your honors don't have because it's not part of the record, and it's $3,158.59. Clearly, the court adopted this as this is what the wife's need was. The court subtracted what was the net, which they're required to do. So the court was correct when it adopted this, and then came up with what the wife's expenses were, what her need was, and subtracted the net wages. If you then turn to page 1242 and you go to the bottom of that, you will see after going through, and the letter of course explains some of the items that the wife had indicated through her counsel at the time, former wife indicated through counsel at the time, should not have been included. So those items were reduced from here, leaving the remainder of the items. And the issue we of course have is as to some of the expenses that Ms. Powell has now raised on appeal. If you had the other information, you may be able to understand why the court left these in there or not, but you don't have that record, which I would submit is an issue that the appellant should have provided you with the full record. But you will see that we determined, based upon the imputation of the income, $6,728.16, which comports with the court's findings in the appeal, or not in the appeal, in the transcript that you were provided as part of the supplemental record, and specifically addresses then what his expenses were and then what his ability to pay was, which was a little bit over $1,400. And it appears that Judge Moody rounded up to the next 100th by saying it's 14 and some change, we're going to make it $1,500. To answer the question of where did this $196.21 come from, so we're now at $1,600. As I said, it's not pretty, but it's there. If you look at that, the letter that I provided was before the hearing that we had on May 26th. And that's what the letter specifically says. Once again, the court did not have to include the letter, could have just included the comparisons. If you look at what Mr. Hurwitz provided on behalf of the former wife, it was provided on May 31st, after having heard the arguments that we provided and having had the opportunity to review the letter and the comparisons. You will note that it specifically says that this chart is post-final hearing and was edited by the former wife specifically. When you flip to that chart, which I had to say I had to use a magnifying glass and 2 pairs of readers to be able to read because it's tiny. But if you review that, the wife specifically says that the net on the health insurance for the minor child in the amount of $196.21 should not be included because it's already included in the child support guidelines. It's a double dip. You then go to the child support guidelines that were attached at, I believe it's 1247, and you there see where the court put the health insurance expense below line where it should be, and you can see the gross numbers indicated at the top. And if you look at the data sheet, you see where the court imputed the $1,535.41. You see the only thing the court removed was the taxes, as the alimony is non-deductible and non-taxable, then you turn to the husband and you see that it was the $6,249 plus the $2,500, which were discussed before. Once again, you don't get a deduction for, and you see where he is taxed in the amount. And when you do all that lovely math, you end up with the same net number that the court came up with when you go back to the charge, which is the 1535, although it should have been, that's where there is, as I indicated, harmless error. But there's where you then find where the net number that's indicated on page 1242 of the exhibit B as attached to the final judgment of the $6,728.16. I would also just point your honor's attention to that same chart where they indicated, hi, you're not supposed to do this net health insurance for the child. It's a double dip. They also included that same net income determined by the court with the stipulation as it relates, or sorry, with the imputation of income of that $6,728.16. I will say that in the supplemental record, when you review the transcript, specifically starting on page 210, and you review it, you will see where there is a conversation about how the court gets to the net. And the judge originally starts with accepting the net that was on the client's financial affidavit of the $6,249, excuse me, gross, I misspoke. Then you see where the judge says, fine, this is what I determine his net is based upon that number. And then the judge asks, because I have my laptop in front of me, I'm using Tools for Law, same program that the judge uses, can you go ahead and run what the $25,000 or $2,500 a month would be and take out the taxes? We have a conversation about how you cannot separate those two and how you must add that to his income because he's taxed at the same level if you added those two together. So if he actually received $2,500 a month, or yes, a month, as is the imputed bonus or commission says, he would receive an extra $30,000 a year. You can't tax that separately because it would be taxed at a lower tax bracket. Rather, you must add it to what his base is because he will be taxed at what his base plus that commission or bonus is. And so that is the conversation where you see on page 2124, where the court understands that our client would be taxed at, or the former husband would be taxed at the 24th percentile. And as such, we put that in there. And then I will say we literally had a show and tell. And that's where I say to the judge, and it's on page 2124, line 19, all I can show you, I can literally, and then I ask if Mr. Hurwitz and I can approach the judge and have the laptop and you can see us having a bench conference. You later in that argument see both of us referring to the amounts as it relates to the gross wage and the imputation. And you can see the argument I make where I beg and borrow and hope that the judge will go back to the amount that we asked, which the judge did not. The judge then specifically says he used the net, and he specifically, when he said he's finding the net, indicated all he did was take their gross and back out the taxes and the FICA, which you can't get out of. Unfortunately, Uncle Sam likes all of those things. And that's what he did when he reached the net for both the gross or for both the former husband and the former wife. So having answered where did the 1696.21 come from, I will go forward with that the court did provide the findings necessary. While not clean and neat, the court did go through all of the elements as required by statute. They discussed the standard of living, the fact that the parties had gone to Orlando with the wife's parents on 2 occasions, and the wife's parents paid for the trip, and that they would travel to Crystal River where they stayed at the vacation home of the husband's parents. They went through the length of the marriage being 12 years and 5 months. They talked about the age. The wife, the judge specifically says the wife testified that she had some mental health issues. The court never made a finding that the wife had some sort of mental health impairment, but specifically did that. The court then discusses the imputation of wages and addresses, when you're talking about the distribution of the assets and liabilities and the financial resources, the funds that the wife took during the 2-year and 5-month dissolution of marriage litigation time period, as well as the funds that she was going to receive. And the court specifically lays out what those findings were as it relates to the.
Ms. Hooglander, can I
Yes.
interrupt you?
Absolutely.
I know you're going, and let me go back.
Sure.
Having heard you mentioning in the record and piecemealing all that, and you're basically saying that the court got it right in terms of the amount, that it was net, and based on your references to the record, which I was able to pull up, the court did, it appears the court did that. However, how do you reconcile the actual final judgment itself that says that there was a gross income? What that seems to be a mistake, almost like a scrivener's error. I should be instead saying net income as opposed to gross. And if you have that discrepancy, what do we need to do about it, if any?
I think that it's, as I mentioned before, I think that the court, instead of reducing the comparisons and here's the expenses I found, but oh, look at this chart for it, and here's where I came up with the ability to pay, and here's where I came up with the need, and reducing all of that, it was easier for the court to say, hi, I started with these grosses, here's the net that I got to, and oh, by the way, here's the expenses, and here's where I got to need an ability to pay. I think that instead of reducing that all, and I can't imagine how difficult it would be to reduce all of that into, the court instead pointed us to an exhibit, and it would be similar if they had said, hi, we entered into this equitable distribution, and somebody might be complaining about that. And they pointed, please see the chart where it would have the breakdown. That's what the court did here, is referred to there, where here's the expenses, here's the net income that I previously determined, which was referenced in the letter that was attached as well as in the transcript. And here's what I came up with as it relates to need and ability to pay. The court, I think, here did more by leaving those exhibits in and by leaving all that information in, provided all of the expenses that they I guess allowed or permitted or felt were appropriate. They allowed those and then came up with need and ability to pay. It's not pretty is all I'm going to say. It's not pretty, but I think the judge got it done. It's just not in the face of the, it's not on the face of the 9 pages of the actual final judgment itself. It's in the exhibits that are attached there too.
Yeah, and that's where the issue comes up, is that, if you read this cold without referring to the exhibits, you have to basically jump through some hoops to read the exhibits, to piecemeal together in order to arrive at whatever amount that's indicated here.
I will say I referred to 2 cases, and I'm going to butcher the name of one, but it's Agdogmag, which specifically stated that the court upheld judgments that omitted specific findings on its arrival where the record demonstrated where those numbers came from. And I believe the exhibits is attached as part of the record show how the court got to the numbers that it got to. Also, we did argue Worthen versus Worthen as it relates to that even if required findings were omitted, if they made no attempt to show how the error was harmful, which here we've shown it's not harmful. The error that was made here was the court imputed her net as her gross. That is, but it's harmless. It benefits her. When you go through the child support guidelines, our client actually had to pay more in child support because her income was reduced. The court took the taxes from the net number instead of from the original gross number. But on the Horowitz case, I will say on that one, the trial court failed to make any findings regarding the monthly expenses. It's attached in the exhibit. These were the expenses. The court adopted the $3,158 and some odd cents. The court adopted that number, which meant that the court accepted the expenses as listed on the right-hand side of that table. It also said that it didn't address the ability to pay, and it did address it. We had the same table, which the court, it appears, accepted, because when going through it, it ended up saying $1,500 for the $1,427. That was the difference that we had. And I will say too, the court's finding of the $1,500 was done 3 days before the letter and 3 days before this comparison that was created was even presented to the court. So clearly Judge Moody, when he was doing his notes and considering his calculations, had calculated the expense as reasonably close. Whereas when we went through using, and our letter clearly says, based upon our notes, which of course I'm human, we make errors, but based upon our notes, this is what we believe it to be. But it's within $70 of what the judge came forward with. And then the explanation, oh, I'm sorry, Judge Liverett. Did you cough?
She actually,
Oh, okay.
No.
I'm sorry. I thought she was going to say something. I apologize. But as it relates to that, I mean, Horowitz, I think, does not apply here because the court has made these findings. They're not pretty and they direct you to go somewhere else to find it, but you can follow the timeline and see where it is. And at the end of the day, in the child support guidelines, is the net income, is the alimony amount that was determined, and specifically references. It's not pretty, but the judge got the job done. I would also say that if you have any questions for me, I think that's all I have.
no, Ms. Hoover, I guess before you leave, my only concern, I mean, you did, considering this is your first argument, you did a very good job. And I think the panel would agree with that. And I guess that still doesn't help the fact that the final judgment doesn't list the net income. That's the struggle that I have right now. And you've explained it, you explained it beautifully by referring to all of that, but that's where my struggle is right now.
Understood. And I think if the court is inclined in that direction, then I think that the court should affirm the decision, but remand this back to Judge Moody and instruct him to do the work of taking the information where he went, hey, look at exhibit B and C. It tells you everything you need to know. And instead have him reduce that into the final judgment. But as it relates to the other items, that I believe would be the only reason to remand it back to Judge Moody. I believe that that he addressed the other items. I will very briefly, because I did not address the issue of the alimony chosen.
Very briefly, Ms. Hooglander, because you're out of time.
Oh, okay. Then I'll say this very quickly. Transitional alimony, as we all know, does not exist. Bridge the gap alimony is for a shorter period of time than durational. Durational alimony is what was requested. And I understand the argument of permanent and temporary. And I would argue that you're stuck with the four corners of your pleading and you need to say permanent periodic or you need to say temporary alimony. And by making that argument, you don't then ask for permanent periodic alimony. And the requirement for the judge to say why they chose durational does not apply. Judge only had to make a finding as to need and ability to pay. If he had ordered permanent periodic, then and only then was he supposed to put into his findings, this is why I chose permanent periodic versus any of the other ones requested. That's all I have. Thank you very much.
Okay. Thank you, Ms. Hooglander. Ms. Powell, you're up.
Thank you. So the first thing is, thank you, Ms. Hooglander, for the context of the final order. I'm going to have to defer to her calculations. I tried really hard to follow along. But I think I appreciate her knowledge of the issues below, but I think the problem is that's where we're at here, which is us that haven't been in the trial court below wouldn't have been able to figure out how to make those expenses make sense. At least I couldn't. So, I mean, that may not be, maybe I'm making an assumption about you guys, but I couldn't.
I think this is really your whole point is you're supposed to be able to divine from the final judgment without going on a treasure hunt through a million different pieces that on the face of the judgment, what exactly the trial judge did, what numbers he used, how he arrived at his calculations. And your argument is, we don't know what he did because he didn't do that.
Right. And that leads into the issue with the expenses, which I think still remains. So I think one thing that we didn't really address in the her rebuttal is that these expenses are still an issue. I think I heard my colleague note that if we had transcripts of all of the proceedings, we might be able to glean whether the court accepted certain expenses over other ones, but we have a transcript that talks about what the court said about the expenses. That was at the hearing that we have a transcript of. And at that hearing, the trial court stated, I'll just read it because it's easier. The trial court stated, listen, people, I mean, expenses are very fluid and I look at it, but they're very fluid. And they can do as much as they want in the expenses. I look more at income, net income. It's not that I don't listen to expenses, but people can find all kinds of things to spend money on. I don't weigh it as heavily as I do on income. And then the court actually went further to say that he wasn't, to my memory, that he wasn't considering expenses specifically. So I can appreciate that the parties submitted their own competing expense reports, and then the court had to figure out, okay, what is the need and ability? But it seems he adopted or rejected certain amounts from those expense reports, but at the hearing, he never even stated which ones he was adopting or rejecting. So I think in that case, when you haven't talked about that at the hearing, because your position at the hearing was, I don't really consider them, you've got to put in the order which ones you're accepting and rejecting. And that goes back to the Horowitz case, which talks about there is an indication that the court accepted and rejected certain amounts. There's just no indication of what those were. So you can't even determine the propriety of the award. I did.
Ms. Powell, because you just have very few minutes left, so what's the remedy? Ms. Hogarth indicated that, well, if it's not on the face, that perhaps we would remand. What is your position? Do you agree that would be just simply remand for the court to set forth what his reasoning is?
Again, this is where I started in the beginning with this is a little bit of guesswork. I don't agree that it's just as simple as court, put your findings in there. If the court has the findings, great. But I think part of the problem is with the expenses, they didn't even go through them at the hearing. It's just in these separate charts. I think ultimately what the court needs to do is, if this court reverses, the court needs to go back, revisit his findings, recalculate the alimony, the need and the ability based on his notes and his findings, enter an order accordingly. And if he can't do that, then hold a new final hearing to do a calculation based on the findings from that final hearing. That would be the relief that we're asking for. I can appreciate it's been a little while and that the court goes off of notes and memory more often than they go from transcripts. So I can't negate the possibility that maybe the court doesn't have a memory of the expenses. And I think, again, that goes back to why they're supposed to be so clearly delineated in the amended final judgment. This is a non-discretionary thing that the court shall put these findings in the order. So, and then I just want to touch on the durational alimony thing one more time. Again, I agree to the extent that I haven't found a case that says the court is required to put in findings when they're awarding durational over permanent alimony, but the statute says that durational alimony is appropriate when permanent periodic alimony is not. And so I think that to comply with the requirement to include the correct findings or sufficient findings in the order, the court would have to have something in there as to why it chose to award durational alimony and why it chose to award the durational alimony for the amount of time that it did, especially considering that it awarded it for only less than half of the marriage. And in the transcripts we do have, I don't have any indication of why that is. So again, I just want to conclude and just ask the court to please reverse the amended final judgment so that the court can revisit the alimony and expense determinations for the need and ability, as well as the type and duration of the alimony. Again, as Judge LaBritte touched on, this isn't supposed to be a treasure hunt. We're supposed to just be able to look at the order and determine what the court did and why. And I thank you all for your time. And if you have any other questions, otherwise I'll be wrapping up.
Thank you both very much. It's a well-argued case.
Thank you.
In order